constitution was 6 months, and the proclamation of emergency and the proclamation suspending fundamental rights had to be passed by Parliament every 6 months. But Ayub got his supine Parliament to renew the proclamation of emergency, although after the Tashkent Declaration of January 66, there was absolutely no emergency. The only emergency was that Ayub feared criticism. And as you know, the Ministry of Information had made us believe, and we were stupid enough to believe, that we had won the war in 1965. Therefore, the Tashkent Declaration led to a mass campaign in the Punjab against Ayub. In that background, the Supreme Court gave one of its finest judgments, Asma Jilani's case, in which, reversing a dozen of its own judgments, it held that High Courts and the Supreme Court could review a detention order under the detention laws. But again, you see the linkage. The tide had turned against Ayub, and the court was able to take advantage of the turn of the tide. We had our second martial law on the promise of holding elections, and that promise was honored to the hilt. We had our Constituent Assembly, a new constitution in 73, which ended in martial law within a little more than 4 years. How did that happen? Well, I would say the first and biggest mistake was that the PPP government kept the emergency in force throughout the period of the Constitution, except for brief intervals of 12 hours and 24 hours. So the Constitution never became a reality to the people. If fundamental rights had been in force, I think there would have been much more opposition to martial law. The second was the dismissal of the provincial government in Balochistan without any justification, in my opinion. And the third was the Supreme Court's decision upholding the federal government's decision outlawing the National Awami Party. But by doing that, the PPP dug its own grave, because the result of eliminating the secular opposition was that leadership of the opposition went to the religious parties who had their links in the army, and well, that led directly to the martial law of 77. The validity of that martial law had come up before us, and we had taken the second alternative of trying to control it. We rejected General Zia's claim to abrogate the Constitution. We rejected his claim that courts could not issue writs against martial law authorities. And elections were first announced, and we validated martial law only to hold elections. Therefore, the validity of the regime depended on the promise to hold elections. They were postponed from 78 to 79. In 79, you had the case to which our friend referred, the murder case, and then the hawks in the army felt that, well, why bother about the courts and why bother about our promises to the courts? They cancelled elections. Therefore, the validation given to martial law ceased to exist. To meet that situation, the Constitution was amended by the insertion of Article 212A, which said that no writ could be issued by the High Courts against the martial law authorities. So, it was an attempt to overrule our judgment by a constitutional amendment. We were in Peshawar on circuit, and the Deputy Registrar came to me that the Chief Justice has flown to Pindi and you have to be in charge of the Supreme Court until he resumes duty. After the weekend, Anwarul Haq came back and told us what had happened. He said the generals wanted to abrogate the constitution, and he said with very great difficulty we persuaded them not to abrogate the constitution. So we said, how? He said, we prepared Article 212A. Maulvi Mushtaq Hasan had written 212A in longhand, we were told, and Anwar said, and I made some corrections in longhand. And Anwarul Haq was completely convinced that he had saved the country. Well, I suppose it's a possible view because my two colleagues who were with me, the late Justice Abdul Shah and Justice Halim, both got up and congratulated. And possibly it averted the clash for a year or so. Well, naturally the validity of Article 212A was challenged by Mr. Pirzada. It was challenged in all the high courts. The only correct decision was of the Balochistan High Court that the amendment, by destroying the writ jurisdiction, was contrary to our judgment. Now we were going to hear all the appeals about 212A in March 1981. And then came the Ides of March, and thereafter I ceased to have anything to do with the courts. Then began a period of ruthless repression. I'll give you one example. A PPP worker was sentenced to 14 years by a military court, and he was sentenced to 14 years by another military court for not appearing before that court. But he could not appear before the second court because he was in jail under the sentence of the first court. So it only illustrates that martial law is no law. Now, the severity of this repression led to something which the generals had not anticipated. Thousands of people went to jail, hundreds were flogged, and that created an awakening which totally destroyed this concept which people in West Pakistan had, that the will of the government is sacred because the government means the state. And General Zia was forced to give the 1985 constitution, but I think we must give credit to two other sources. There were officers in the army who were also against martial law, and the aid-giving countries used their influence for the lifting of martial law. Mr. Pirzada has referred to it as the Eighth Amendment. I disagree with him. He described the salient features of the Eighth Amendment. Now, the term Eighth Amendment means that there were 7 amendments and that this was the next. Well, in fact, there were 7 amendments to the 1973 Constitution. But this amendment changed the essential features of the 73 Constitution. It ceased to be a parliamentary democracy, and the power of amendment does not mean the power to change the essential features of a constitution. When Nehru, who, thank God, was an unsuccessful lawyer and and therefore a great statesman, introduced the amendment clause in the Indian Constitution to the Constituent Assembly of India. He said, I ask you to pass this clause and be assured there's no danger in it, no hidden trap, because an amendment only means the power to make a minor change here and a minor change there. So this is called it the 1985 Constitution. Now, after this 85 Majlis-e-Shura elected under a partyless system came into power, they immediately passed a law legalizing the party system, and I would have thought that destroyed the moral sanctity of their election. But then, you know the joke that when Iskandar Mirza appeared before the Almighty didn't get up. So Mirza said, Almighty, you got up for every president, why not for me? He said, well, unfortunately, Pakistanis have a habit of jumping into the chair and sticking to it. Then this assembly passed another shocking law. Every MNA and MPA was given a development grant. You know, to placate this demand for more local self-government, all right, give them a development grant, but they were not accountable for that grant. So that led to wholesale corruption, including corruption in the elections, because many sitting members used those funds for their election campaign. Now, meanwhile, of course, the third martial law had wrought its havoc. You had the Shariat court, you had the Hudud laws, you had separate electorates. All the demands of the theocrats had been met. Then, in '88, exercising this new power under the '85 Constitution, General Zia dismissed the Junejo government on the ground that the government was not being carried on in accordance with the Constitution. That is the language borrowed from the Government of India Act, which was never meant to be the constitution of a free country. It was meant only to be a stepping stone to another constitution. Well, he was dismissed, and the rumor goes that then he realized the consequences of his action, and he sent for his legal gurus, who advised him that now get someone to challenge the dissolution of the National Assembly so that the National Assembly can be restored. Because you really should not have dissolved the Assembly, you should only have sacked Junejo. Now that writ petition was filed in Lahore. I forget whether it was allowed or dismissed. But in appeal, the Supreme Court held that there was no ground for dissolving the Assembly. But you see what happened, that the government, the federal government, did not produce any evidence to support the allegations made by General Zia in his speech dismissing the government and dissolving the Assembly. So, the dissolution was patently illegal. And if the dissolution was illegal, the Assembly was lawfully in existence. But the Supreme Court said, no, we have not had elections. They, without saying so, they treated the Majlis-e-Shura as a rump assembly. So we will refuse to state the elections. Now that part of the judgment I cannot understand. Because if judges depart from the law for a good purpose, they can depart from it for a bad purpose also. It is more important to follow the law. Well, elections were held in '88. The PPP formed the government in a difficult situation. Its great contribution, I think, was to give total freedom to the press. No doubt that freedom was used against that government, and I think the intensity of the criticism of the press, my assessment is really reflected more than anything else the deep-rooted male chauvinism of our society. So, then she was dismissed in August. Mr. Pirzada said in June that he thought that the Ides of March were coming. I was in Islamabad in July. I had the same feeling. And then, you know, proceedings were taken against her under President's Order 17. And I cannot understand why the PPP government could not repeal that obnoxious order. Because the opposition would certainly have supported her in repealing it. Well, these things happen. It was also a mistake on her part to challenge her dismissal in the courts, because that is a political issue. And if you ask judges to adjudicate political questions, they will go by their own political views. No doubt many cases have political overtones, but this sort of case has nothing but politics in it. Now a new government took over, and one of the grounds, as Mr. Pirzada pointed out, for dismissing the old government was the law and order situation in Sindh. Yes, it is terrible, but it is the legacy of the army. First of all, because they allowed the drug mafia to build itself up, and I have a strong suspicion that the drug mafia also involved in all this kidnapping forensic, because that diverts attention of the police from their activities. Secondly, and more important, the Afghan refugees were allowed to violate their hospitality by selling heavy caliber rifles to all and sundry. How could a police force equipped with 303 rifles put down kidnapping gangs armed with Kalashnikov rifles? Secondly, Karachi now has the same population more or less as London, Bombay, Delhi. The police force in all these other cities is over 40,000. In Karachi, until 1988, it was 13,000. Then it took the PPP government 6 months to decide to increase it. But again, the fault was of the military government not to increase the police force. What has happened? A total running down. And the scapegoat, politicians have to find the scapegoat, and they made the courts the scapegoat and have set up speedy courts and special courts. But unfortunately, special courts were set up in 75. Now, I would even accept the 12th Amendment if it solved the problem of kidnapping. But the problem is, first of all, witnesses are frightened of giving evidence. I personally feel this factor is exaggerated by the police, because whatever they may have done in the interior in 87 and 88, now when they come to kidnap, they muffle their faces. And can you honestly identify a person whose face was muffled? And yet, without that evidence, it is very difficult to obtain a conviction. I was once at a function when an ex-judge, my colleague, former colleague, Fakhruddin Ibrahim, as governor, condemned the courts that they are acquitting people left and right, and what is the police to do? But what are the courts to do also? Secondly, the police are under-equipped. Thirdly, they are corrupt. Then fourthly, the DIG Hyderabad has repeatedly said that about 20% of the police force are in league with the kidnappers. I do not think setting up special courts or terrorist courts or speedy courts will solve any of these problems. So the 12th Amendment makes a dent in the rule of law without serving any purpose. But there is a silver lining in it. You see, Mr. Pizarra didn't refer to the terrorist affected areas ordinance which was promulgated on the 11th of July. The tribunal envisaged under that court can truly be described, could have been described, not can be, because it can't come into existence now, could have been described as a kangaroo court in the real sense of the word. You had fantastic provisions. On the demand of a public prosecutor, the trial could be in camera. The period for filing an appeal against a conviction was 1 week, and the court had to decide the appeal in 1 week. Now, you could not have passed this silly law without suspending fundamental rights. So, the federal government first attempted an amendment in the Constitution empowering the Prime Minister to suspend fundamental rights in the exercise of his own discretion. Then something extraordinary happened. First of all, the press took up a very, very bold campaign against it. I was present on the 14th of July in Islamabad at the French Embassy National Day. I met 2 ministers and I protested to them about this amendment. And in the presence of people who must have been itching to rush back and give the replies of these ministers to me, to the Prime Minister, both of them said they were against the amendment. And the Prime Minister had to give up that amendment. And this 12th Amendment is really a face-saving device. First of all, as I say, it has made a minor dent, because the principle of special courts, the really obnoxious principle, had already been introduced in 75. Now, one of the 2 judges in Sindh appointed to the Speedy Court, I personally have a very favorable opinion of his integrity and ability. But this provision to finish the trial in 1 month, you see, in the days of the Sindh High Court, trials were concluded in 1 week. So what has been done can be done, provided the police cooperate. But if you do not give any flexibility to the law, the police will not cooperate in order to protect the real culprits who can bribe them. This is my objection to the law. And my objection would have been that the amendment was passed without a debate in half an hour, but as I told you, it goes back to 1948. Now, we have all had very gloomy speeches. Is there any hope for the future? The most hopeful sign is the freedom of the press. And this was a heartening development, that the members of the majority party asserted themselves against their Prime Minister. But the press began exercising, the pioneer, I think, in exercising that freedom, because that happened in Junejo's days, when newspapers were somehow frightened of exercising their freedom. The Frontier Post, for some article I forget, its staff was physically beaten up, the machinery was damaged, but what was much sadder, nobody protested. There were other attacks on other newspaper offices, nobody protested. Between 1987 and 1989, 3 journalists were murdered, nobody protested. I protested in a speech in Lahore. The newspapers gave full coverage to my speech, except my denunciation of the murders of 3 journalists, because I said this is how the Nazi party had come into that why were the leaders silent when journalists were murdered, and they are protesting so loudly when somebody is beaten up? Well, the answer is one wrong doesn't right another. But he had a point. And And this is what dismays me. And there was no, in any other country, the public would have come out in a procession against the murder of a journalist. Now what is this due to? My view is, it is due to the obscurantism revived by the third martial law. As I said, the battle of ideas between a secular state and a theocratic state began before we came into existence. It began on the night of the 11th of August 1947 when civil servants tried to black out Mr. Jinnah's speech. And the Shariat Act, well, I am as worried as Mr. Pirzada is, because anything which any third-class magistrate, I'm sorry that's a bad expression, any class 3 magistrate may think is inconsistent with the Sharia, he can declare illegal. He can say freedom of speech is against the Sharia. And it's not only class 3 magistrates. A man whom I greatly admire, the late Justice Hamulur Rahman, he spent his life administering the common law, which was based on the liberal humanism of the 18th century. He never renounced that when he was Judge and Chief Justice. But unfortunately, in 1985, he said that the Majlis-e-Shura was in accordance with Islamic principles. He said the powers exercised by General Zia were in accordance with Islamic traditions. And he said that parliamentary democracy is against Islam. So the forces of reaction are very, very strong. And unlike us, they are organized and determined. And I am very much dismayed by the inability of people to protest at the time. I will end now with a story about one of the great leaders of the resistance against Hitler, Neomela, Pastor Neomela. He was a Junker. That was the military caste which put Hitler into power. He was the commander of a submarine in the First World War and got an Iron Cross 3 times or 4 times. He admitted that he was a supporter of the Nazis because, you see, he was an ardent nationalist. And exploitation of nationalism and exploitation of religion are the two sources which have enabled would-be dictators to overthrow democratic institutions. But then suddenly he turned to religion and he became a pastor in the Lutheran Church. And then he saw that this nationalism was an evil because it repudiated those human rights laid down in every religion. As an ex-naval commander, as a naval hero, even the Nazis were afraid of arresting him. They begged him, but he would not compromise with his conscience. He spent about 10 years in concentration camps, and he was one of the few who survived. On his release, he was asked by some journalists of the American Army that, can you explain how a highly educated nation organized itself into a reign of terror? His answer as a model for us. He said, when they came to arrest the communists, I did not protest because I was not a communist. When they came to arrest the Jews, I did not protest because I was not a Jew. When they came to arrest intellectuals and writers, I did not protest because I was neither an intellectual nor a writer. When they came to arrest me, there was no one left to protest. Well, if you work for it, my generation and Shah Saab's generation, we are passing out. But if you fight for freedom, I hope you will succeed, because there is one great change between now and 1948, and that is the cause of human rights has been universalized. And I think if you fight your battles in Pakistan and use your influence to see that no aid is given to a country which violates human rights, then I think the future is yours.